Hello everyone, this is CS Divesh Goyal, practicing company secretary from Delhi. In this video, we are going to discuss a very common question raised by so many corporates and the professionals through our WhatsApp group and the social media platform. The question is whether if a company has already applied for the ISIN, but company has not received the ISIN till 30th June, whether it can be considered as a non-compliance on the part of the company. So to answer this question, we should go through the provision of the Companies Act, but the actual expectation of the law from us. So if we read the Rule 9B, that is issue of the securities in dematerialization form by the private company, the section is specifically saying every private company other than a small company means a non-small private company shall within the period referred in sub rule 2. Period is earlier was the 18 months from the 31st March 2023, which is extended up to 30th June 2025. So shall be in period means till 30th June 2025. Facilitate dematerialization of all its securities. So if we go through the sub rule 1 and clause B, it's saying within the time period mentioned in rule 2, which is 30th June 2025, every company should give opportunity to their shareholders to convert their share into dematerialize their securities. So practically, to give an opportunity, to give an facility to shareholder to convert their share securities into demat, it is required to obtain the IC number. Without receipt of IC number, company cannot give them opportunity to apply for the dematerialization of their share. So one school of thought, we can opine that if a company is not receiving IC until 30th June, they will not able to give the facility to their shareholder to convert their securities into demat till 30th June. So ultimately, this shall be considered as a non-compliance of the Rule 9B, Sub-Rule 1 and Clause B because you cannot give the opportunity to your shareholder without ISIN. So it is mandatory for you to get the ISIN till 30th June. If a company has not receiving ISIN till 30th June, so definitely we can consider it as a non-compliance on the part of the company. Although we can say there is a delayed by the NSDL, there is a delayed by the CDSL because of the pressure of the work. But all these, we can say, justification is not saving a company from the non-compliance. Ultimately, it is a non-compliance of the company, and ROC in future, ROC may raise the penalty and issue the adjudication of penalty notice to the companies. In such case, definitely, company can represent before the ROC and justify that we have filed the application, but it was pending with the NSDL, but it was pending with the CDSL. But ultimately, whenever these type of cases will be considered by the ROC, definitely they should consider what time application has been filed. For example, if the application is filed on the 28th June, and we are saying we have already filed the application, we have not received the IC. So this should not be proper justification. But in the another case, if the company have already filed the application 6 months back, but due to some issues with the NSDL or CDSL, if they are not getting ISIN, then definitely they can request the ROC to leave the penalty and to impose a minimum penalty. But in other case, it doesn't seem that it will not consider as a non-compliance. Definitely, it will consider as a non-compliance. So make sure all your companies on which ISIN, on which dematerialization provision is applicable, they get the ISIN till 30th June. So if you have any question, any query on the same, please mention in the chat box or the comment box, or you can send this to the WhatsApp also. We will try our best to help you with your answers. Thank you so much.